Good afternoon, everyone, and thank you for joining us today. We are thrilled to welcome you to the very first session in what will hopefully be a long series of monthly webinars hosted by Digital Beehive, featuring a host of NEC and industry experts, clients, partners, contractors, and the wider NEC community. So just before we get started, I'll go through a few boring housekeeping points to mention. So you'll notice that everyone's camera's been turned off and microphones have been muted for the duration of the session. We've disabled comments, but the Q&A functionality has been enabled. If you have any questions during the session, please submit them through the Q&A. When you do click into the Q&A button, which is next to the chat button, you'll be asked to either start a discussion or ask a question. If you just flick to ask a question, it'll just make it that little bit easier. And then we'll either address those questions as we go along or during the allocated Q&A session at the end. So this session will be recorded. Everyone's cameras are off, so it shouldn't be an issue, but we will be sharing the recording with all the attendees after the webinar. So we're very excited about today's session. It's part of our ongoing commitment to support NEC contract management and the wider NEC community. So we have, as Digital Beehive, recently partnered with our guest speakers today, Glenn and Neil, to make sure that we are continuously improving our NEC contract management software, Contract D, ensuring it remains the most compliant and practical software on the market. Their expertise combined with our software insights allows us to tackle real world challenges that project teams face on a day-to-day basis. And that's why we thought it'd be fitting for us to team up to deliver our very first webinar. So on to the topic today. Managing NEC contracts can be complicated, and even experienced teams can fall into avoidable traps that cause delays, disputes, increased cost. So today's webinar will highlight the most common mistakes made in NEC contract management and hopefully provide you with a clear and practical guidance on how to steer clear of them. So you will hear from our guest speakers today, Glenn Hyde, Director of GMH Planning, and Neil Earnshaw, Director of NE Consult. And together they will be sharing best practices for identifying and managing risk, the importance of early warnings, how to approach compensation events consistently, and how to apply NEC's collaborative principles to achieve better project outcomes. So without further ado, I will hand you over to Glenn and Neil, who will take you through today's session. I think we'll start, aren't you, Neil?
I am. Thank you, Brad, and good afternoon, everybody. Nice to have you all here. So I'll kick off the webinar with a look at early warnings. Early warnings is often a part of the contract that is misunderstood by people working on projects. It's often seen as a negative thing, and people don't like it sometimes when it's done to them, whereas early warnings should actually be seen as a positive thing. So firstly, just one of the practical things we see on our contracts that we work on is that, we do have the ability to effectively give each other pre-contract early warnings. So it's possible to list in contract data part 1 and part 2 matters that will be included in the early warning register once we've signed up to contract. So the idea is that we're doing some pre-contract risk management. And you'll see there's a reciprocal entry in contract data part 1 and contract data part 2, where the client and the contractor can give each other that pre-contract early warning of anything they think might compromise performance of the contract from a time, cost, or quality perspective. What sometimes is misunderstood with this part of the contract is that what it does when we enter something in that part of contract data, that it acts as a trigger for liability. It describes who owns the risks, and that isn't the case. That's not the function of doing that. Liability for risks in the contract is dealt with principally through the choice of main options, sometimes through the choice of secondary options as well. And also it's through how the compensation events are described under clause 60.1. So that entry point in contract data is not the space to try and shift risk onto the other party by, for example, the client saying things like the contractor is to allow for this, or the contractor takes the risk of unforeseen ground conditions, for example. That wouldn't be a correct entry to see in there. But what the client might do is any specific concerns they have about unforeseen ground conditions, they could flag them up. So they may have had some geotechnical reports done that indicate that there is contamination in one part of the site, and it's going to need carefully managing post-contract. So they might flag that up as an issue in contract data, contamination of the site. Okay, not attempting to allocate the risk, just flagging it up as an issue that is should be discussed from an early stage in the contract. And it's the same for the contractor as well, that it isn't the space for the contractor to try and shift risk back onto the client by making risky statements such as we've not allowed for this, we've only included for this, or we have assumed X, Y, or Z. That's definitely not what we should be doing. So that's the key thing to start with. Is it's a pre-contract risk management tool. Okay, is what we do, and we're putting things into the as early warning matters in contract data. Actually, a little bit of history, if you go back to NEC 3, which was first published in 2005, and then it was overtaken by NEC 4 in 2017. NEC 3 and the contracts before that referred to a risk register, and that's where this common misconception came from, that it's allocating risks. And so NEC positively decided when they published NEC 4 to go away from that language and to remove reference to a risk register and to replace it with the language of an early warning register and early warning meetings instead of risk reduction meetings, to clearly illustrate what it's intended for and how it's intended to be managed. Okay, so that's my first part of early warning. What about linking early warnings to compensation events? So again, an issue we often see is this misconception that people think that you have to have an early warning notified before a compensation event can be notified, and that's not correct at all. Early warnings can be notified that don't become compensation events, and actually a compensation event can be notified that didn't have an early warning prior to that. Okay, if you look through the reasons for not accepting an event as a compensation event in the contract, it doesn't mention early warning in that stage. There's only one reference to early warnings when the project manager instructs the contractor to provide a quotation. The project manager can basically flag up to the contractor that they don't think the contractor did give an early warning that they should have done, and that should really be taken into account in the assessment. So no, we don't have to have an early warning notified before we can have a compensation event. But if we haven't notified early warnings, the risk for the contractor is that the assessment of a compensation event is reduced, that you don't recover all the costs and all the time through the compensation event on the basis that the absence of an early warning meant that things turned out worse than they could have done had there have been an early warning. So if we already have an issue, then, and it's already occurred, so there's no opportunity to mitigate, something's happened, it's already occurred, we should just move straight into notifying it as a compensation event. Because remember, the whole point of notifying an early warning is to get us to an early warning meeting where we discuss and agree the mitigation. So if there's no opportunity to mitigate because it's already happened, there is no point in notifying an early warning. It's supposed to be used for things when we're looking ahead at what could impact delivery from a time, cost and quality point of view, rather than about things that have already happened. Okay. Then what about responses to early warning then? So do we have to reply to early warnings within the period for reply, for example? And the simple answer again is no. There's no obligation to reply to an early warning per se. The early warning the response to it is what happens in the early warning meeting and what is discussed and agreed there. So there's no requirement for a response where it's acknowledged or confirmed. It's dealt with through the early warning meetings, and the actions and decisions are recorded in the early warning register. Now, many of the cloud-based systems are used in industry to manage the flow of communications don't help with that misconception, because many of the systems indicate that you have to reply to an early warning within the period for reply, but that isn't what the contract actually says. And maybe that's why sometimes, maybe often, you see quite banal responses to early warnings in contract management systems, where somebody just says noted, for example, is a common one that I've seen. So remember, it's functionality in a system. It's trying to promote good practice, that we're just flagging that we've seen it, we're aware of it, or whatever, but technically not required. And actually, we should make sure that in our early warning meetings we record what was discussed and agreed in terms of actions and decisions, that we record those within the early warning register. So yeah, that's my key point on early warning. Glenn, I'll hand over to you now.
Brilliant. Out of interest, Brad, with contract B, how do you deal with that? Is it mandatory to respond to an early warning or not within contract B?
So we don't mandate the response to an early warning within contract B, and we actually allow for people to issue early warning actions and early warning meetings within the system as well. And we don't include the early warning responses in the overall compliance score of a contract either.
Brilliant. Good. That's what I hoped you say. Yeah, I see this a lot where a lot, particularly clients, they haven't responded to an early warning and they've got an action and it shows as a red action that they've not done something. And the whole thing about early warnings is most of the responses are in the meeting, and so they're recorded on the register. So that's good. That's what you've got settled within the system. Yes, you want the option to respond, because sometimes the response might be all that's needed, but it shouldn't be mandated, and certainly there shouldn't be the system saying, you know, you've got an action and it's almost holding against you because you've not responded. So that's good. Yeah, so really common issues there Neil's highlighted with early warnings. Okay, moving on to the sort of compensation event quotation phase. And here the question is, can a contractor include within a compensation event quotation their own assumptions? And this is a really common thing I see, where a lot of contractors do put assumptions within quotes, whereas if you look at clause 61.6, it only talks about the project manager who can state assumptions within for the contract to take into account when they're assessing the compensation event. And if they do, so if there's an element of risk that could be difficult to foresee, then the project manager can give an assumption, and then it's going to reduce the amount the contractor's then going to have to put in terms of risk within their quotation. So it's a way of ring fencing it. However, in my experience, project managers are not very forthcoming necessarily with a project manager assumption. And so in the event that the contractor doesn't want to put in a really expensive quote that will probably be rejected because it's too high, they try and help the situation by putting their own assumptions to ring fence the quotation, thinking that if the quotation gets accepted, well, then therefore surely they've accepted the assumption. But unfortunately, that's not the case. There's nowhere in the contract that says a contractor assumption can be revisited, and there's nowhere that says just by accepting the quotation that it does become a project manager assumption. So the only real way around that is for the contractor to propose assumption for the project manager to agree to confirm back in writing before the quotation submitted. Otherwise, the contractor's got no alternative other than to price the risk within the compensation and quotation. So that's in the full ECC contract. Interestingly, in the short contract, it does allow for contractor assumptions, but it's a simplified system. In the full contract at the moment, there's no place for contractor assumptions. We have recommended actually that there is a change to future contracts where there is the option for the contractor to propose one and for the project manager to agree them all before the quotation goes in. So at the moment, we can only deal with that sort of manually, in the sense of you can propose them, but you do need in writing back from the project manager that they've confirmed it. And we can do this within the cloud-based systems as well. So that's something we'll be looking at certainly for contract B, that we will have this, because I think in the future it will be a potential option in the contract in the future, but at the moment we've got to deal with it as it is. The contractors, victims of trying to be too helpful, putting their own assumptions into quotes, thinking that quote can be revisited, sorry, that the assumption can be revisited, and there's nowhere to do that. So only project manager assumptions can be revisited. Is that something you see, Neil, a lot of?
Yeah, absolutely, Glenn. Yeah, it's something that I mean, we've developed a simple mantra, haven't we? There's no such thing as a contractor's assumption. You know, people think it exists, but when you analyze the contract around the assumption clauses, there is absolutely no way for the contractor to make one of their assumptions an assumption that would trigger a compensation event. Yeah, really important what you've said about suggest it to the PM, but the PM actually needs to state it themselves and issue it to the contractor. I've seen a number of clients of mine fall foul of that over the years. Okay. Shall we move on then, Glenn? Sorry, it's back to me, isn't it, Glenn? My apologies, everybody. So moving on then, next issue is delay damages. So what's the issue then if the contract has no delay damages included under X7? Is that a good thing for the contractor? Again, people may think it is a good thing. Nobody likes damages, do they? Okay, so surely if the contract doesn't state damages, surely that's a good thing. However, what that means is that the damage hasn't been liquidated. If the contract is left blank and silent on the subject of damages, then the client obviously can't recover liquidated damages or delay damages, as they're called in NEC, because they haven't been included in the contract. However, legally, they do have a right to recover loss, unliquidated loss, which is basically whatever they can prove. Now, from a client's point of view, it's much more difficult for them to recover that loss because there's no contractual mechanism to do it. So it would have to be done in an extra contractual way, and ultimately through a form of dispute resolution if it wasn't effective. So, not having damages in a contract, having it open-ended, is a particular risk for contractors. So what is ideal really with damages is that what we do is, if the best position for a contractor will be to have X7 in the contract with the damages being stated as either 0 or as £1 per day, and then it's been liquidated from nothing, as in we don't know what it is, to something. We know it's either 0 or 1. Okay, so that's the strongest position for a contractor to be in. Whether a client would accept that or not is down to the individual client and down to the parties to negotiate. So yeah, make sure that it's covered off in your contracts in some way, shape or form. And that's the best way to protect the contractor's interests. Glenn, do you want to take over?
Sure. Yeah, just on that
do you
one.
have anything sorry.
Yeah, I've seen clients who've not filled that in, thinking that they're doing the contractors a favour, saying, no, we're not planning on charging you delay damages. So the test will be, if the contractor says, well, if that's the case, can we set them at £1 a day? And obviously, if they say yes, well, that's clear. If they say, oh, no, we don't want to do that, then maybe there is something a little more that they're up to, maybe as a client in that regard.
Yeah, I always say, people might not like damages, but at least they give you commercial certainty. You know the game you're playing. You know what will happen if you are late. Okay. Whereas if they're not included in the contract, there is a risk, a huge risk on some of these large projects. Okay.
Yeah, indeed. Okay, what else? Here's another common misconception. So lack of response to something issued for acceptance. and thinking that if a project manager doesn't respond to communication within the contractual timescale, well, often this has been viewed as being deemed accepted. And the trouble is, if you don't know that that's not true, then you don't know you've got a problem. So a lot of people would assume that if a project manager doesn't reply to a contractual timescale, to a submission, then surely that will be deemed accepted. But as hopefully you already know, but we're going to reinforce it, that's not the case. There are two processes within the contract, and they are program and compensation events, where failure to reply can lead to contractor notifying that there's been no response, but you do need to put in a formal notification. It doesn't just have to happen automatically. So if they've not responded, you've got to put a formal reminder in that they've not responded. And if then there's a further period, so for program it's 1 week, and for compensation events it's 2 weeks, if there's no further response once the reminder goes in, then that would lead to treated as having been accepted, i.e. more commonly known as being deemed accepted. So just for those areas, it does lead to a deemed acceptance. Again, some of the cloud-based systems don't automate that. I think all cloud-based systems should automate it. And some say, well, we don't want to upset the client. Well, that is contractually correct. And even if a system doesn't automate that, well, they're kidding themselves, because if we went to adjudication, the adjudicator would say, well, contractually, that has been deemed accepted. So the cloud-based systems, I think, have a responsibility to make sure that they do automate that, because it's what the contract says, and not veer away just because the client said, well, we don't want that. You know, the cloud-based system should be, you know, making sure the clients are following the contractual rules correctly. And there's no point in setting up a system that allows them to fudge the rules when that is not contractually correct at all. So that's just for program and compensation events. For all other matters, it would simply be a compensation event. If the project manager hasn't responded within the timescale, any impact that is caused would be fully recoverable as part of that compensation event quotation. So an obvious one would be design acceptance. So if the project manager has not responded to design within the period for reply, then that will be a compensation event. And because the contractor can't proceed without that acceptance, they're now on stop for all intents and purposes. So they would then look for a compensation event to recover any impact that is actually having. So that is, in terms of the project manager, that is the position there, that it would be a CE if they don't respond, apart from program and compensation events. But like I've said, if you don't know that, then you don't know that you need to do anything. I've just come off a program workshop today. So I've done a training session, a program workshop, and I did one yesterday as well. And on both occasions, when I asked early on if a program's not responded to within the 2 weeks, the cloud-based system says you haven't responded, what would that mean? And the person said, oh, it's deemed accepted. And someone on a recent session said, yeah, we've had that for the last 8 months. They've never once accepted a program. They've all been deemed accepted. And when I pointed out they'd not followed this loop about, have you put the reminder in? They said, well, no, didn't know we had to. And that's the point. If you don't know that that's the case, then you're in blissful ignorance that you thought the program is deemed accepted. So, but it's not automatically deemed accepted. The reminder for the program has to go in, and then the further timescale of 1 week before it would be deemed accepted.
Yeah, really good point, Glenn. And that that notification reminding of the failure is what's legally called a condition precedent, which means it has to happen. Without it, it cannot be triggered. And I guess another thing that we see quite regularly, Glenn, is Z clauses that either add further processes on or actually just delete the deemed acceptances. And I always think it tells you a lot about the client's attitude and mindset, that they're not wanting their project managers to be held to account for failing to reply to the contractor, which is basically what they're doing when they're moving the contractor's right to trigger a deemed acceptance. But also, I'd always say, handle this one with care as well. That step number one should always be, pick up the phone, send a polite email reminding, just to say, we were supposed to have a response to the program yesterday. How are you getting on with it? Do you need any more information? When can we expect a response? I sort of often say this is these deemed acceptance clauses are for repeat offenders, people who just don't, no matter what you do to try and get a response, they just completely ignore it. Okay, so that's yeah, sorry, that's all I have to say on that, Glenn.
No, it's a good point. You're far too nice, but yeah, I'll be straight in with the notification myself. But no, I do take the point. Yeah, soften it and then send it. Yeah, compensation events. Why would you want to delete the deemed acceptances? Because it's just going to mean they're open-ended, and then neither party will know where they are. Okay, similar theme. Does acceptance of something by the project manager mean a shift in liability? So the contract talks about the project manager accepting submissions such as design, program, revised activity schedule. What's the potential liability that the project manager has taken on by doing so here? Because a lot of people think, well, they've accepted it, so then they're taking on liability. So they think it is a shift in responsibility. If a project manager accepts a design submitted by a contractor, it's on the basis that it fully complies with the scope. So, for example, if they've submitted something that doesn't comply with the scope and they miss it and they accept the design, it doesn't now mean that, oh, well, the contractor's got away with it. If it's a lower grade material, that they've got away with it. And if the project manager wants what they originally asked for, they'd have to pay for it. No, that's not the case. It's not the project manager's responsibility to go through the design and check every element that it fully complies. It's the contractor to make sure that they do submit something that does fully comply. So once again, if the design turns out to not comply with something in the scope, it will still be the contractor's liability to correct, and they can't simply hide behind the fact that the project manager did accept the design. So clause 14.1 makes it absolutely clear that project manager's acceptance doesn't change the contractor's responsibility to provide the works or their liability for their design. Now, a lot of contractors tell me, well, that's rubbish. That's pointless. Acceptance is meaningless. Well, you just have to understand that it's the opportunity for the project manager to accept, to see if they want something different or they can spot an error. It's not their obligation to check it with a fine-tooth comb and make sure that the contractor's fully complied. And if it did mean that, you wouldn't get project managers wanting to accept anything. So that would be quite problematic. It would encourage wrong behaviours there. So at least it frees the project manager up to say, yep, I will accept this on the basis I didn't see a problem for not accepting it. It doesn't mean they're signing the life away by accepting. The other obvious one is the program. If they accept a contractor's program, if a program shows plan completion beyond the completion date, it doesn't mean the project manager is accepting liability and the completion date can be moved as a result. The only way the completion date can be moved is through an implemented compensation event. So again, program acceptance, if contractor's running 2 weeks late, by accepting the program doesn't mean they're accepting liability. It just means that they are showing they are running 2 weeks late at that point, and the project manager is accepting that position, doesn't like it, but accepting the position, and the CE process will then catch up and sort out, okay, whose liability is that? Only an implemented CE can move completion date. So that is really important. So the various things that the project manager is obligated to accept, their acceptance means something. It just might not mean as much as a contractor wants it to mean, but it frees up the project manager to be able to do their job without fear that accepting something, they're going to sign their life away. Do you see that a lot, Neil, where project managers maybe fear for accepting things for that reason?
Yeah, a lot, Glenn, and I do think that is probably why what we see is people having problems getting the programs accepted, because the project manager fears that they're accepting liability for delay, whereas all they're accepting is that it passed the tests in the contract for an accepted program. And effectively, if the contractor is showing they're late, all the project manager is saying that the project manager thinks that that is a realistic assessment of where the contractor is at this point in time. And I think, yeah, it's important to recognise that traditional contracts used the term approval. Things were submitted for approval, and the approving of things was what the contractor would cling on to say, well, you've approved my design, so now this is equally as much your fault as it is my fault that it's gone wrong. Whereas NEC downgraded from that to acceptance. And I think the whole point of having it in the programme is because one of the fundamental objectives of the contract is to stimulate good management, which I include good risk management in there. So rather than just, not have a process and then something gets built that doesn't comply with the scope, actually by accepting it, we're mitigating the risk of it being incorrect. Yeah, because it's giving the project manager that opportunity to review it and to see if they have any major concerns at an earlier stage, when hopefully the risk can be managed better.
Absolutely. And I think that's another reason why, cloud-based systems actually make sure we use the right language, because they will only use in the default text the word accept. They won't use the word approve. So.
Excellent. Okay. Right. Thank you, Glenn. Back up to me then to look at quotations then. So again, lots of issues we see with compensation events and getting them implemented. Firstly, the question we've got here is, should a compensation event be based on actual or forecast cost? And again, this is a common misconception that people think sometimes that if it hasn't been agreed or implemented and the works have been done, then we should assess compensation events based on the actual defined cost. Whereas that isn't what the contract says at all. Clause 63.1 is really clear about how we assess compensation events. It states that we base our quotations on the actual defined cost of the work done by the dividing date and the forecast defined cost of work not done by the dividing date with the resulting fee. And the boundary between the boundary between actual and forecast, the dividing date concept, the dividing date moves, it's in a different place depending on what triggers the compensation event. So if the compensation event is triggered by primarily an instruction, but it could be a certificate, a notification, or a change decision, then if the compensation event is for one of those reasons, the dividing date is the date of that communication. Whereas for all of the other compensation events in the contract, so things like that are there for project manager or client or other breaches of contract, things like bad weather, ground conditions, etc., all of those compensation events, the dividing date is the date of notification of the compensation event, which could be up to 8 weeks after the contractor was aware of the event. Okay, so it's important that we stick to those rules because that is exactly what the contract says. Do you see problems with that, Glenn?
Yeah. So I think the common misconception is that we sit on clients often might sit on a quotation and then think that they can switch to, well, if we haven't yet agreed the quote, we can switch to actual cost if it suits us. But then really weirdly, when the actual cost is more than the quote, then all of a sudden they want to follow the rules and follow the quotation process. It also does protect clients from contractors who have put in a quotation and then say, well, actually it did take as long as we said, so there, you've got to pay us it. Well, if the reasonable forecast was that it could have been done quicker or should have been done quicker, then the project manager is still at rights to make a forecast assessment and assess it accordingly. So it's a case of just applying the rule.
Yeah, absolutely. And it takes me back to contractors' assumptions as well, that if the effects are too uncertain to be reasonably forecast, then the project manager should state an assumption. So if that's what's getting in the way of the assessment being done, the PM should bring clarity to the situation. And it's back to that whole ethos of proactive management. Let's not wait until after the event and then we'll base it on actuals. We should be doing it prospectively as time progresses, because we know that before NEC had these rules in it, traditional contracts did everything retrospectively, and we know that doesn't work either, because people then argue about what the actuals are. That resource wasn't used for that particular task. It wasn't on site. We haven't got the records to justify it all, and that's what people will fall out about. So NEC, I think, prizes timeliness of decision making over accuracy, which is why we have forecasts, because a forecast by definition can never be accurate. Okay. Okay, moving on to my next slide then. So yeah, always base compensation events on forecast, not actual. If the contractor states the works took 10 days and can prove so through diary sheets and records, it's no bearing on the assessment if the project manager judges that the output that should or could have been achieved in only 5 days. What we're saying is, basically, the compensation events are assessed on the basis that the contractor reacts competently and promptly. Therefore, if when the project manager comes to making an assessment, they don't think that's happened and more resource, more time was taken, they're allowed to make what they think is a fair and reasonable assessment of the actual resource that should have been used. And yeah, we shouldn't be reviewing quotations after the effect, but we do see this happening where it feels like what happens is if we just let time pass and we know how long it took, then we can cherry pick. We can pick the quote more favourable to the client, whether that's based on the forecast or whether it's based on the actual, but that's really detrimental behaviour to the relationship.
Mm-hmm.
So anything else on that, Glenn?
No, I think we've covered that. It's just so hard. People want to use hindsight when it suits them and not when it doesn't. And the best way we can cut through that is to avoid the muddiness that hindsight creates. So try and get CEs agreed in a timely manner, rather than letting hindsight creep in when it just muddies things.
Absolutely, yeah. I was dealing with an issue immediately before this webinar, Glenn, where exactly that had happened. Unfortunately, neither party's been complying with the contract. One of the parties is coming to me looking for advice, and I'm thinking, well, you've not helped yourself. You've not included the delay in your program, and now the project manager is claiming concurrent delay for issues with the quality of work, and everybody's just making things up. None of it is based on what the contract says. So if they're not careful, those parties will end up in dispute. The rules are there to be applied, I think, is the message, isn't it? Clause 10.1, act as stated in the contract.
Now, there's a great comment coming from Gareth Slocum, who has said, what about the healthy buildings case? Now, yeah, this regularly comes up. The healthy building case basically said something on the lines of, the judge said, why am I fumbling around in the dark when I could turn on the light and see what's happening? As in, why are we arguing over what would have been a forecast when we can see what's actually happened? However, the important thing about that has not set a precedent to say, oh yeah, if it goes to court, it's going to be actual cost. In that case, there was lots of Z clause amendments. In that case, neither party administered things. So the judge was kind of, well, what else can I do in this situation? So that's why it went down that road. Really importantly, it doesn't mean that, oh yeah, if it goes to court, that set a legal precedent, it's going to go that way. So great comment, Gareth, but it doesn't change the rule. The contract is very clear. It should be a forecast. And if it goes to adjudication, it should be based on forecast. The only time you'll find out if you might be right is if you go all the way to court. We do not recommend you go down that road.
Mm-hmm. Absolutely, great point, Glenn. That case very much turned on the specific facts of the case, and the main ones being neither party had complied with the contract, and they'd ended up in a mess. And then the judge, because they'd been through adjudication before that, ended up in front of a court. The judge has to award damages. How on earth are they going to do it? But please don't think that is now a contractual shortcut that we should be applying. It absolutely isn't. We should try and stick to the contract as closely as possible. Okay. Thank you for that one. Was that Gareth that asked that one? Good question.
It was Gareth. Yeah, it's a great point.
Mm-hmm. Great.
Yeah, he's quoted, why should I shut my eyes and grope in the dark when the materials are available to show what actually work they did and how much it cost them? Yeah, that was the quote.
Yeah, and actually that, I think what happened in that case is exactly what we were talking about, the cherry picking, where the client didn't respond to the contractor's quotation. They waited until the work had been done. Then they asked for timesheet records to validate the forecast, which incidentally the consultant refused to provide, which is a different issue. And so you could see what they were trying to do was, if I get the actuals, then I'll validate the quotation. So they're trying to cherry pick. So you can kind of understand why the consultant was reluctant to hand the timesheet records over, because I suspect they didn't justify the forecast. But that's completely operating outside the contract from the client. And actually that, I know we're going on to talk about mutual trust and cooperation in a second, but basically the judge highlighted that as being the antithesis of mutual trust and cooperation, the refusal to hand over records. which is interesting because it kind of, you can see how the consultant was conflicted. If I give them the records, I know what they're going to do with them.
Yeah.
So interesting case. But yeah, remember, turn on the facts of both parties being in breach of contract, and that's what led them to the dispute in the first place. Okay. Should we move on to the next one, Glenn, then?
Yeah, go for it, Neil.
Okay. Who's in control here? Instructions. Is this one you or me?
So project manager instructions. You can run through this one.
Okay. Okay. So, is a project manager's instruction always something a contractor can recover time and money against? And the answer is simply no, not always, not in every instance. So some instructions that the PM gives would have to be separately notified as compensation events if they are for one of the reasons listed in clause 60.1. So you don't recover time and money against an instruction, you recover time and money against a compensation event. And most of the compensation events are at clause 60.1. Again, I always separate the clauses in the contract into operational clauses and commercial clauses. The instruction is what gets the work done. That's operational. The compensation event is commercial. It's not about, there's only one instance where it's about getting work done, which is if it's a proposed instruction. But all of the other compensation events, the work's already been done. And all the compensation event does is deal with the time and money associated. So yeah, instructions to change scope would be a compensation event, or an instruction to stop work would be a compensation event, assuming the reason for that was not the contractor's fault. So let's, for example, if the instruction to stop was something to do with a security breach or a health and safety issue, then that wouldn't be a compensation event. However, if it's for convenience, so the project manager said, no, stop, I want to check the design here. I'm not sure that's right. Assuming it was the project manager's design or the client's design, then that would trigger a compensation event more likely. So not all instructions will allow you to claim money. For example, the project manager could instruct the contractor to remove someone from site as they're acting unsafely, or instruct them to comply with their own quality plan. Assuming the project manager was right to do that, then that would not be a compensation event.
Yeah, that's a real common one. And I do find sometimes some project managers are reluctant to give a contractor an instruction because they are fearful that the instruction is something they can recover. Or equally, the contractor thinks, oh, well, we got an instruction, so therefore we're covered. The project manager can give an instruction just to clarify something that's in the scope. And if it is a clarification, well, then they're not going to pay for it, but they are confirming this is what we definitely want. So project manager should be empowered to have more confidence. Yeah, I can instruct you to do something, but there's no intent to pay money for that because that will not be a compensation event. So they should be freer to give those instructions. Same for contractors with subcontractors, probably even a bigger case there where you can give an instruction to a subcontractor to make it clear, this is what we want you to do. And if that's already part of the subcontractor scope, then they can't claim for that as a compensation event. Okay, I don't know why we left this one till last, Neil. So this could be another webinar all on its own, doesn't it? So What does it really mean to act in a spirit of mutual trust and cooperation? Well, just in one slide. The parties, the project manager and the supervisor, should not stop following the rules of the contract with a view that they must do this to be considered to be acting in this 10.2 spirit of mutual trust and cooperation. An obvious example, we're always banging on in training. If you've had training from myself or Neil, we would have every single session said you don't follow verbal instructions, and you certainly shouldn't follow them on the basis that you think you've got to do it to maintain a good relationship. Spirit of trust and cooperation is not at the expense of the good relationship, it's as well as, and remember clause 10.1 says you act as stated in the contract, and in this case 13.1 says it has to be in writing, 13.2 says it has to be in a cloud-based system if the scope has identified one. So no one should expect anyone not to follow the very rules that the parties have signed up to by entering into that contract just on the loose guise of a spirit of trust and cooperation when I want you to do something that's not in accordance with the contract. So that's the easiest way you can sum that up. It's still first and foremost following the contract. It's not about just let's slip into that when all else fails. We'll just we'll latch on to the spirit of trust and cooperation and hope you're going to do something because of that. I don't know if that's enough sum up, Neil. It's hard to do that in just the 60 seconds, isn't it?
It is, yeah. My golden rule with those words is that they should be seen and not heard. The minute people are saying the words, what's happening usually isn't what the words mean. With a common scenario being a lively conversation about a compensation event quotation. Ultimately, when we don't agree, ultimately one party says, come on, mutual trust and cooperation. In that context, what they mean is you just need to agree with me now. So when you hear those words, when they're uttered in that kind of cynical way, you should really direct them to the counterpart words in clause 10.1 that say act as stated in the contract. Okay, so yeah, an awful big subject that I'm sure we'll come back to later on, Glenn. There is a lot to say on that subject, but I think there was another case as well. It was a Scottish case, Van Orden Dragados, I believe it was, where the judge said it's not a charter for contract breaking. Doesn't mean you can just do what you want to do. You've got to do both things in clause 10, act as stated, and in a spirit of mutual trust and cooperation. And that's the challenge with NEC. It doesn't mean you're always going to agree with each other, but we should agreeably disagree. We should stay professional.
Yeah.
Yeah. Okay. And follow the rules.
Right.
Okay. Indeed. We've got 10 minutes left, Glenn, so I think we should deal with some of these questions.
Yeah, well, one I can go back to Andrew Jarrett. We'll hand back to Brad for a bit of a closeout. But one, Andrew said, just a clarification on your point, he said, is there a standard to what will be deemed as a reminder for the PM to respond? Can it be a polite reminder, as Neil alluded to, or does it need to be more direct and clear, quoting requisite clauses so it's the clear condition precedent has been met? Well, I like what Neil said. I like what Neil said about, look, pick up the phone, tell them, that's like a soft reminder. Yeah. But if you don't get an instant response from that, then the contractual requirement, like anything, is in writing and separately from other forms of communication. So the reminder, there should be within the cloud-based system a contractor's notification whereby you can put the reminder in formally, very politely, but formally, and then it starts the clock ticking. I think that helps the client's team though, because it reminds them they've got an action to respond to. Otherwise, it could lead to a deemed acceptance in that position.
Yeah, absolutely, Glenn. The reminder is notified, and as Glenn says, has to be in writing, has to be separate from other communications. So just think of it like, what are the other notifications that need to be done? Got early warning notifications, compensation notifications, defect notifications are the main ones. They all should be communicated separately and in writing. Okay. Yeah. So yeah, I say what I was advocating was more of the mutual trust and cooperation. But if that doesn't work and doesn't get the response you want, you have to do it more formally than that. Okay. Great.
Liam's asked one before we head back to Brad. Again, this could be a big one, but Liam said, what happens with clause 63.1 when a CE was rejected? However, when the project is completed and adjudicator decides a rejected CE was actually a CE. Okay, that will be a complicated one, but I mean, the rule is there. That if you had a CE rejected, you will have known on your program how long it's taken you, although it was rejected as a compensation event. So you should still be able to go back if an adjudicator says, well, actually, that was a CE. If you know it's taken you 4 weeks, but it was rejected as a CE, you should be able to go back to that program and prove, okay, it will be at the point you issued the program, you might have projected it was going to be 4 weeks. Ideally, it would still be a forecast. But that one would be a little bit more tricky to unpick, but the principle is still the same. But the good news is you should have, if you've got a regular accepted program, you shouldn't be too far away from an accepted program at the point you knew it was a CE, but even though it was rejected, you still had the program works on the program there. Yeah. So that was quite
I was going to just sort of say, well, it depends what question you asked the adjudicator to resolve. Was it a question of principle? Was it a question of quantum? Or was it both? Depends what jurisdiction you're giving the adjudicator, really. So, yeah, good question, that one.
Okay, well, Brad, as I hand back to you for the overview, I think Mark has probably set you up a lovely one here. As contractors, How should we perceive projects where the project manager or client doesn't want to use a cloud-based management tool? Okay, well, Brad, that's the perfect time to come back to you, surely.
Yeah, well, I'd probably be a bit cautious and try and understand the reason why they don't want to use a contract management system. There's a lot of value and a lot of benefits of using a cloud-based tool. So I'd probably dig into why that is. Is it a training need? Is it that they are not wanting to highlight some of the ways in which the contracts are being managed? Sort of one of the ways that I'd maybe look to combat that is speak to your preferred contract management provider, your software provider, and maybe work with them to approach the client and sit down together to sort of explain the value and the benefits of using a tool in order to collaborate on the contracts.
Mm-hmm.
Yeah, definitely. Actually, Mark, I think the more interesting question possibly, what about contractors who don't want to use cloud-based systems with their subcontractors? Because when we did the survey last year, I think the stats were 72% of people are using it between client and contractor, and only 33% were using it between contractor and subcontractor. I could say that some contractors don't want to show how they're not managing subcontractors. Equally, contractors say that they complain about subcontractors not doing very well, not following the rules, and yet don't use a cloud-based system. If they did set a cloud-based system up with their supply chain, it would channel the subcontractor to have to do the right thing, and it would just bring up, they would naturally encourage them to do the right thing, follow the right processes. And I think it's important. I'm always about education. We want to educate whichever party is along the supply chain. We want to educate and nurture them rather than be using this as, it's not a tool to beat people up with. It's a tool to help people manage, help our projects be a success.
Yeah, completely agree with that. I think also what Brad was saying about educating the client, there maybe is a perception that they cost a lot of money, and that money won't be seen as a beneficial way of spending it, whereas you can actually demonstrate savings from using them. And I think the different tools out there, they all have different commercial arrangements. So maybe as contractors, do some research, find out, from a pricing point of view, how the different systems work, to be able to then demonstrate the benefits to your clients.
Excellent.
Agreed. And I think just before we summarize, I think there's one question that's been missed, and it's from, where was it? Sorry, from Peru. So Manus has asked, please explain the workings of clause 25.3, even though it's not mentioned in the workshop today.
Very quick overview of key dates, Glenn.
Yeah, so 25.3 is where if there is a key date identified in the contract. Now, first of all, people there you go, there's another misconception. Key dates are anything that's key. No, the only key dates that exist is key dates included in Contract Data Part 1, Section 2 by the client. So these are going to be contractor deliverables that the contractor needs to achieve because the client wants something achieved for someone else. Normally it's dealing with sort of third parties, other interfaces. It might be, an example I give in training is provide power to a certain area because the client's got someone else coming in who needs power. So the contractor might not need it, but the client needs it. So that will be a key date. Not everything that's key is a key date. Only key dates are key dates as listed. And clause 25.3 that Manus then brings in is the ramifications if a key date is not achieved by the contractor. And in very simple terms, 25.3 says cost incurred by the client as a result of the key date being missed is then recoverable from the contractor. So the big point there is this undefined, unliquidated cost hanging over the contractor's head, rather than the delay damages that we get with key dates and sectionals.
Indeed, yeah. And I think key dates can be problematic for contractors for partly the reason you said, Glenn, that liability for failing to meet a key date is additional cost incurred will be deducted, but also the contract gives the PM the power to instruct changes to key dates, so they can force you to accelerate using a key date mechanism. That would be a compensation event. but it could still be problematic for you. So yeah, key dates, and I have to say that the drafting in was it 25.3 isn't the best drafting. I did write an article on this subject a few years ago, Glenn. It's on my website, it's on my LinkedIn profile, but it isn't clear because it says additional cost, so that must exclude loss then, consequential loss, because it says cost, or does it? It also says on the same project. Okay, but what does that mean? What's the project? It's not a defined term. And then it says in carrying out work. Well, what is work? Is that physical work on site, or could we also recover the other contractor's prelims for the delay? So I think there's a number of challenges with the drafting that make it uncertain for parties, to be fair.
Yeah, definitely. I wrote an article with Rob Horn, who's a very learned lawyer in our industry. Rob, I wanted that legal input as well. So again, that's something else you can read up on. But yeah, thorny issue that's not straightforward at all. So Brad, you've got a whole minute to wrap this up.
Yeah, well, I think we've just had another question from Liam, but I think what we'll do is we'll follow this up with a recording of the session so that everyone's got access to it. And if you want to send in any questions, we can go away and put a response together and then send those questions and responses back out, because I think we've run out of time now. So quick summary then.
I might just be able to answer Liam's question very quickly, Brad.
Go on then, Neil. Go on.
In like 10 seconds. To me, reading into what you've put, Liam, it sounds like you've got an issue with defects. If the contractors fail, if you've notified the defect to the subcontractor, if they fail to return to correct it within the period required by the contract, then you can assess the additional cost of having somebody else correct the defect. Okay, so that's a simple sort of mechanism there. Sorry, Brad, I'm done now.
That's fine. That's fine. I've got 30 seconds. So contractual rules need to be understood and then administered properly. This will require ongoing education of project team members and people calling out things that they believe not to be contractually correct, and using a contract management software definitely helps with that. So I think that's us finishing bang on time. So I just want to thank everyone for attending, and I want to thank Glenn and Neil for your time and your expertise. There's a couple of ideas that I've got for additional webinars based on a couple of the slides and some of the questions around subcontracts. So keep your eyes peeled for future webinars, and we'll see you all again next time.
Thanks, Brad. Thanks, Neil.
Thanks very much.
Everybody.